let's get started and talk about basic conveyancing principles and the law that sits behind it. I have in the past lectured on land law, and land law's really boring. I don't know if you've attended any land law lectures in the past, but it's dreadfully boring. But when you start putting it in the context of conveyancing, it becomes really interesting. So it's important that we understand some of the building blocks of law that sit behind the conveyancing process. And the first one I mentioned is the law of contract. Now, contract is the creation of a binding agreement between parties. I could buy a pair of shoes, I could buy a car, nothing in writing, just an oral agreement. But land is special and requires a formal written agreement in the vast majority of cases. There are one or two unusual exceptions, which we'll look at later in the series. But for our purposes today, we need to understand about contract. Now, fortunately for you and I, in residential transactions in England and Wales, the formality required to create a legally binding contract has been simplified. There is a standard contract form that we use, which the seller completes, sends to the buyer for approval. The buyer, if they approve it, then gets their client's signature to the part contract. The seller gets their client's signature to their part contract. And then when contracts are exchanged, when the agreement is formally entered into, there's a swapping of the contract, the exchange of contract that I'm sure you've heard of and probably deal with. But in order for there to be a valid exchange, normal contractual principles have to apply. There has to be consideration or a purchase price. We have to know who the parties are. We have to know what all the terms of the contract are. And all of that is dealt with within the contract. So we need to know a bit about contract law. We also need to know a little bit about land law. England and Wales and the law of the land in England and Wales is really interesting because basically it's based on the law that was created in the Norman conquest in 1066, namely that all land belongs to the crown or the king. You might think, Ian, that's nonsense. If I own the freehold to my house, I own it. Well, that's not strictly true. You own a legal estate in the land, but if you were to die without a will and without any family, your land would vest in the king. It would automatically go to our dear friend, King Charles, God bless him. He needs the money, so it must be nice. I do a little bit of work for the Treasury solicitors who work for the Crown estate, and they tell me that the Queen, God bless her, before her death, used to inherit about 13 houses a year because people wouldn't have a will, wouldn't have any family, and by default, she would acquire the property. So it's important to understand the basic principle that all land belongs to the Crown. However, it is possible to have absolute ownership of land in England and Wales, which is the nearest there is to entire ownership of the land. So ideally, when we're buying or selling land, we want to have what's called fee simple or a freehold ownership, which is the best form of ownership you can get. Okay? So there's freehold ownership, and there's only one type of ownership of land available to us in England and Wales, and that's leasehold ownership. You might have heard of common hold. Common hold is very unusual, but in essence is a variation of freehold. So we're going to be looking at, to start with, freehold conveyancing, the sale or purchase of an absolute ownership of land in England and Wales. And most of that land will be registered land. And that means that we need to look at the Land Registration Acts that started in 1925 and culminated in the Land Registration Act of 2002.